Providing.
You may be seated. Good morning. Yes, hold on just a second. My computer is black. That's not a good sign. It has been one of those mornings. Okay. Calling to you, my computer suddenly will not tower on. Is present with both his lawyers. Mr. Levine is here for the state. The jury is on the way up. Mr. Hertel tells me, but before that, do either of you have any authority on the issue that we were discussing yesterday?
I do, Your Honor. I found a couple of cases that seem quite illuminating. Your Honor, beginning with Tallman v. State, for the record, that's 120 Southern 3rd, 593. Tallman is spelled Tallman. And on page 1 and 2, it mentions that a juvenile does not have the right to exclude a parent from access or control over his or her personal belongings. To hold as such would undermine the inherent authority of the parent. The second case, State v. SB. And for the record, that is 758 Southern 2nd, 1253. Has a similar holding, including, we hold that by virtue of his parental authority, the father's consent overrides the juvenile's objection. And then it talks about some of the rationale behind that, including a father has the responsibility and authority for the discipline, training, and control of his children. In the exercise of his parental authority, a father has full access to the room set aside for his son for purposes of fulfilling his right and duty to control his son's social behavior and obtain obedience. When a parent basically, the parent can, like the first case said, can do as they see fit. The parent is exercising his or her parental authority and control over the unemancipated minor child. So I would submit that those two cases coincide with one of the court's inquiry regarding that subject matter, Your Honor, and that would further support the finding that the text message in conjunction with the attorney-client privilege law and arguments and subject matter we discussed, that should be admissible, Your Honor.
And did you place the case names on the record yet?
Yes, sir.
You did? All right. Ms. Thornhill?
I have a response, as well as some cases, but I'll get to them if that's all right.
All right.
First, I found no authority that talks about a parent's unlimited right to go through everything. I understand the cases that Mr. Levine cited in connection with the Fourth Amendment issue, but of course we're dealing with a different issue slightly. So, parental rights assume that the parent is acting in the best interest of the child. I think that's the foundation. But the child also has rights vis-a-vis the parents, and those rights change over time with the age of the child, right? So a 2-year-old or a 4-year-old, obviously a parent has much more control and much more ability and authority to intervene in their child's behavior, their belongings. As the child gets older, the child's rights increase in relation to their parents. At any rate, even if you find that this mother, Kathy Griffith, had the right to snoop or right to go through Collin's cell phone, I still have arguments that relate to his right under the Fifth Amendment and his Sixth Amendment and his privilege to communicate privately with his attorney. So first, the privilege is only waived if at the time the communication was made, Collin intended it to be disclosed. And you mentioned, should he known or should have known that his mom might look. That's possible, but we still have to look at his intent and then what the mother did with her, I'm going to call it snooping, looking. When we talk about people who are in jail, inmates, even though they have very restricted liberties and their right to privacy is severely curtailed, there is still a means by which they can communicate privately with their lawyer, right? So we have attorney booths at our jail that are private, are not monitored. So they have that ability to exercise their privilege. If an inmate makes a choice to call their attorney from the monitored line, say just call on the phone, they are warned at the outset. This is being recorded and monitored. Anything you say is not private. And if they choose to use that phone, then shame on them and the privilege is waived. But the important thing is that they have a feasible option to exercise their confidentiality privilege. But what choice did Collin have? We talked about this. Could he have made a phone call? As you pointed out, there are surveillance cameras everywhere in the house that could have picked it up. Could he have gone to his attorney's office? He didn't drive, he didn't have a license. Could he have called his grandmother in another county? Possibly, but is that reasonable? A child has restricted agency by virtue of them being a child. He didn't have any other feasible options. And I don't think a child should have to give up a privilege because they are a child, which is essentially what the state's wanting you to find, is that unless the child can somehow on their own, or if their parent's not willing to cooperate, can get to their attorney's office and go inside the office without their parent, then they can't exercise their privilege. It's like putting the burden on the child to do something extra to preserve a privilege that other people have easier access to, which seems unfair. But in addition to that, Judge, I may have been wrong in how I deal with parents who want to be present in privileged conversations. Because the case law indicates that due to parental authority, but that also includes duty, because parents are close advisors, and it's natural that a child would seek advice from a parent, and that a parent would want to be involved to some extent in making sure that their child is represented adequately, also to facilitate the communications, so driving the child to the office, providing the phone by which the child could call their attorney. There is a case that I found, nothing in Florida that's directly on point with this particular issue. It's Doe versus Town of Greenwich. It's 473 Federal Supplement 54. It's from the District of Connecticut from 2020. A brief rundown of the facts. Two minors had an interaction where the female alleged that the male had attacked her, had sexually assaulted her. It's not a criminal case. The girl's family, on her behalf, sued the Town of Greenwich, saying that they had not provided adequate supervision and investigated the criminal case adequately. So that's kind of neither here nor there. At any rate, the suit was between the girl and her family and the town. The girl's family, and it's unclear how they got these emails, but they obtained emails between the boy, now he was a non-party, but the boy and his lawyer and the boy and his headmaster from his school that discussed what he had discussed with his lawyer. All right, so the kid himself actually disclosed to a third person, his headmaster, communications between him and his lawyer. And the federal district court held that even though the other side already had them, and even though the child had purposely, so very different than what we have here, purposely told somebody about those communications and shared them, that the attorney-client privilege still existed and that those communications were not admissible in court. So a couple things with this case. The court found They talk about how minors are treated differently than adults out of the recognition that they do not always know, due to lack of maturity and world experience, what it is they should be doing or not doing. And given the various protections afforded minors in the law, it seems particularly harsh to summarily find that Roe, the boy, waived his attorney-client privilege when he shared privileged communications with his headmaster. During the investigation, Roe, the boy, was 16 years old. There was an investigation into his behaviors that left him scared and anxious, and it's clear that he considered his headmaster to be a friend and source of guidance and support. It goes on to say that under the circumstances presented, the court concludes that Roe did not waive his attorney-client privilege by virtue of his disclosures to the headmaster. So it talks about the protection of children and their rights, given their unique positions as sort of subservient to adults in their life. I would argue that the headmaster is analogous to Kathy Griffith. It's not a completely on point analogy. But Collin communicating with his lawyer and knowing that his mom might find it doesn't excuse, and this is something that this case also discusses, doesn't excuse what the mom does with it later. And that's my second point. That's that, okay, so maybe you find she had an absolute right to look through his communications with his lawyer. Or maybe, as her duty as a parent, once she realized they were privileged communications, she has a duty to act in the best interests of the child and not go sharing those with other people. And certainly that shouldn't translate to, if she does make the bad decision to breach the attorney-client privilege, to allow it to be admissible in a court of law against her child. She also was the alleged victim in that particular case, so she bears some responsibility in doing what's best for Collin. I think she violated that duty by sending it on. And even though the cat's out of the bag now, I don't think that her maybe having a right to go through clearly privileged communications gives the state the right to use that in this criminal case. She was the parent has to act in the child's best interest, as I said. But even if you're engaging in some weighing of the rights and responsibilities and duties and the duty of a child to obey their parent, it doesn't wipe away the privilege that exists. I provided RLR 116 Southern 3rd 570 from the 3rd District Court of Appeal in 2013.
You have not given me that yet.
No, I gave it to you at the hearing.
Oh.
But I'll give it to you again. It basically talks about even if it would be in the best interest of the child to deem the privilege waived, in this case it was for the protection of the child, it still means you can't violate the attorney-client privilege. Additionally, under Florida statute section 90.5021C2, talks about that disclosures to third persons who are necessary to the communication between the defendant and the lawyer, or between the client and the lawyer, are not waived from the privilege. So if you accept the state's position that the mom had every right to do everything she wanted with her kid, but she is the only way, or the sole way, that can facilitate the communication between Collin and his lawyer, and she's the one who controls the phone, apparently, then even if she found the message rightfully, it still doesn't mean that it's waived. And she doesn't have the right to waive his privilege, even if she is in a position of authority over him. The privilege belongs to Collin. I'm almost done, I promise. Then we also, sort of as a logical argument or an overarching view, if you decide that Collin waived his attorney-client privilege by using a phone that his mother controlled and had the right to look into, if you take that to the logical extension of it, then how is a kid ever supposed to communicate privately with their lawyer unless their parent can facilitate it, in which case then they would never have the right because their parent would be the third person that was involved, which I think completely vitiates the purpose of the attorney-client privilege and should not be a rule.
All right, so Thornhill, I had essentially come to a very similar conclusion as yours, agreeing with you. First of all, recognizing I believe the law is clear that a parent has the absolute right to determine what extent the child will have privacy in that relationship. But I agree with you that there's an overarching duty of the parent to act in the child's best interest. And when a child is facing legal jeopardy, that would, and that's recognized across divisions of court, dependency court, family court, criminal court, a parent has a duty to act in the best interest of their child. And that's probably, in fact, why that absolute right of surveillance exists, so that you know what your child is getting into or is being exposed to, so that you can make the decisions about guiding that child, providing the appropriate services, and so forth. So the right and the responsibility go hand in hand. And I think that's something that we fail to recognize across the penumbra of rights that we have these days, that they come with responsibilities. So I agree fundamentally that a parent, when it comes to an evidentiary privilege, meaning those secrets that they find in the locked box being what would otherwise be subject to a claim of privilege, that parent has a duty to act in the child's best interest with respect to those secrets, even when the parent is at odds with the child with respect to those secrets. Now, that's not to say I don't believe the parent cannot act on those secrets. For instance, call law enforcement, separate herself from the child, even initiate a Baker Act, file criminal charges. But what I have a hard time with is that once that child is sitting here in front of a judge and a jury, whether that circumstance could ever operate to waive the claim of privilege, when it is just the parent who it was exposed to. But Mr. Levine presented me this case, and I need you to tell me how it's different, because although it's a Fourth Amendment case, that evidence would have been suppressed. Otherwise, that evidence would have been suppressed if the parent did not have a right to consent to a waiver of an important constitutional right, which is to be free from unreasonable searches and seizures and have that evidence used against you in court. How is this different? Because in essence, it's sort of the same. And that's the law in Florida. A parent can consent to the search of a child's bedroom, and that had not even crossed my mind during our discussion. So what is the difference here? It's evidence being used against a child in court. One, it's okay, and one, you're saying, and I initially, through my thought process overnight, agree. But what do we do with that case?
I think that those situations are distinguishable because the government is acting, right? Your Fourth Amendment right is against the government from engaging in unreasonable searches and seizures. And when the government comes and says, I want to search your kid's room, the parent, as the parent with rights and responsibilities, and maybe not knowing what's in the room, because if the parent had snooped and known what was in the room, then they would have a duty to do with it what they thought was best for their child, right? But here we're dealing with a government actor intruding on a private place that the parent pays for, that the kid has some duties towards the parent too, and the parent can say, all right, government, come into my house and search, right? That's very different than a mother who on her own has the duty to protect her child, the duty to act in the child's best interest, who goes looking through their private communications and then shares it with people, okay? It's another thing. Even if Collin knew his mom was going to look at it, if she's facilitating the communications, that doesn't mean he intended it to be disclosed to everyone and be used against him. So I think that because the
specific privilege is not directly on point.
Because the government wasn't acting at the time here, and mom took it upon herself to totally destroy his attorney-client privilege by sending it to Susan, and then Susan, maybe by accident or not knowing the implications, then turned her phone over to law enforcement. I think that's too many steps removed from a government actor coming to a home that the parent owns and controls and says, can we search your kid's room?
So what about the circumstance where the state issues an investigative subpoena to mom and says, tell me what's in that phone, and the mom willingly complies? How is that different? And says, yeah, in his phone he said he was going to stab me in the neck, to his lawyer. And
I still think it would be privileged.
But how is it different?
Hold on.
They're both essentially at their core evidentiary privileges. I mean, I think unreasonable search and seizure is broader and protects individuals' privacy as well. But it also is subject to the rule of exclusion if there is an unreasonable search and seizure. So at its core, it's an evidentiary.
Well, but
issue.
we're also dealing with something a little bit different in that we're dealing with a privilege of confidentiality, which is different than living in your bedroom, right? So, for instance, with the psychotherapy patient privilege, a parent can't waive that on behalf of their child, even if they know what happens in those therapy sessions, because it's the child's right to confidentiality in certain things. And there are very few
So it's
privileges.
because the child doesn't own the bedroom that it's different, is what you're saying?
No,
Because
not
it's
entirely.
the parent's right to determine who has access to what they own.
No, the law doesn't provide a child an absolute privilege like it does in their bedroom, like it does between a lawyer and the child as a client. We have to start from that place, not the backpack he's carrying, the room he lives in, where a government actor is trying to find something. We're dealing with the privilege exists. Very few privileges exist that keep things completely confidential. This is one of them.
Right, so Mr. Levine, you have a response to that, the consent to search a bedroom is different than consent to give up confidential attorney-client communications.
Yes, it's not, Your Honor. I mean, both are evidentiary issues at their core because ultimately the state is trying to use evidence, however it was obtained, and I submit that it was obtained lawfully. What Kathy did was not illegal or diabolical. It was Susan Detman, which I think is beside the point, but nonetheless, it was Susan Detman who consented to giving her phone and that information to law enforcement. It wasn't like Kathy, who would have been within her right to go to law enforcement and say, look at this, my son is saying he's going to stab me in the neck, and he's already killed his dad in Oklahoma. And the only reason I say that is because obviously the jury's not here. So it's not like...
I remember I didn't say she couldn't use it, like for purposes of protecting herself, getting him services, whatever it may be. I didn't say she couldn't use attorney-client communications for other purposes. The issue is whether that means she can consent to waive the confidential nature of the communication in a court of law.
No, nobody's waiving the communication for him.
Well, that's essentially what I would be doing, is saying because a parent's absolute right to surveil their child exists, that every child knows or should have known their parent can find it, and thus it's waived.
No, I don't think it's that broad, John. But in terms of the admissibility, there's reasons and court findings, including some of the cases I gave you the general topic matter, where the attorney-client privilege, the evidence comes in court. If it was such an absolute right, then there wouldn't be any case law and there wouldn't be instances where a court has a discretion to allow it in. So this is not earth-shattering or groundbreaking if Your Honor lets it in terms of it happens under certain circumstances. The circumstances being such as the case law and the issues that Your Honor is weighing. But in terms of whether it's the attorney-client privilege or it's the right for unreasonable searches and seizures, at the heart of it is the court being the gatekeeper. Both are governmental action. It's no different because the ultimate thing that can be helpful to the prosecution of a case or hurtful in terms of evidence against the defense is if that evidence comes into court. So both are evidentiary issues. They're not these different things. The end result is the same. The state is acting. The state is trying to get both evidence in, whether the question is suppression for an illegal search and seizure or suppression because of a legitimate attorney-client privilege protected statement, which I've mentioned many reasons why it's not. So the end result is the same. The court has to determine, should it be admissible or should it not? Was it an unreasonable search and seizure? Was it legitimately an attorney-client privilege? And based upon the case law and the inquiry about should the defendant have known or reasonably known that his mom was going to see it, and was the statement when he made, was he thinking it was attorney-client privilege? Obviously, he could simply walk outside and take one of his walks that he so much loved to do, make a phone call, we wouldn't be here. When he made that statement, too, he wasn't thinking about it being protected or it not being protected. He was just saying it. So at the risk of repeating everything I've been saying, I have nothing else to say.
All right. Anything else, Ms. Lorna?
No, sir. I
All right.
think you understand our position.
I think the difference lies in the fact that the law has said a parent can consent to the search of a bedroom of a child, and the child has no exclusionary claim under the Fourth Amendment for not consenting himself. When we're talking about the attorney-client privilege, I have not seen a case, and you have not presented one to me that says point blank a parent can give up a child's attorney-client communications to law enforcement, and that right has always been personal to the client. And until and unless the court decides otherwise, that it's personal to the individual, I don't think this case is analogous. And finding that a parent's absolute right to surveil their child serves as a tool for their responsibility to act in the best interest of the child, in this case and under these circumstances, means that when it is just the parent who the child might have reason to believe will see what's in the phone, there could be circumstances where this wouldn't apply. If he knows that he's sharing communications in an environment that others are going to be aware of that don't have a duty to protect him, that's a different story. But even when a child's interests, legal interests, a child in legal jeopardy, even when those interests are contrary to the parent's personal interests, that doesn't vitiate the parent's duty to act in that child's best interest. And I think we see that in court downstairs in dependency when the parent is the victim of a domestic violence incident, for instance, in juvenile court. The parent still has a duty under those circumstances. It doesn't vitiate that responsibility. So that being said, I do not find that in this case, even though Mr. Griffith knew or should have known his mom was going to look through his phone, that in and of itself, with respect to her and her alone, in any way would have waived the confidential nature of the communication. Again, finding that the state, while the actual communication itself was unusual, eerie, it was also apparently in the context of some discussion about self-defense, and there were no other facts elicited at the hearing, no other context provided where I could say that the crime fraud exception applies. So in that respect, I am going to exclude it.
Judge, if I could inquire, and of course I respect the court's ruling, could I just inquire, is it also your finding that when the defendant made that text to Jeffrey Rapkin, that he intended, at the time he made it, that it be privileged and a confidential attorney-client privilege, as opposed to now he wants to keep it out because it's going to hurt him?
Mr. Levine, you've asked, if you keep saying a person has to say in their head, oh, I'm typing this message, it is attorney-client privileged. I don't think that's the thought process someone has to go through. I think the thought process is, I'm sending this to my lawyer, and my lawyer alone. I'm not sharing it with anyone, and especially when we're talking about a child, that the law should not require that child to even understand that the attorney-client privilege exists. Per se, word for word. I mean, the child's right to confidential communications with their lawyer, when the communication itself indicates that it's about seeking advice from a lawyer, especially in this context when Mr. Griffith was currently accused of a crime, that burden should not be placed on a child to have to make that mental connection. And I'm not even certain anyone goes through that particular process in their mind when they're talking with their lawyer. So I'm not going to answer your question because I don't think it's necessary under the circumstances. All right. Anything else we need to take up before the jury comes in?
Can I make a call downstairs to tell my assistant that Jeffrey Rapkin will not be needed for these proceedings? He was waiting on standby should the court rule that it was admissible.
Yes.
Thank you.
And I have no objection to him being released.
All right. All right, are we ready for the jury?
Yes, sir.
All right,
Yes, sir.
for the record,
Before that, Your Honor.
for the record, Mr. Griffith is present with both lawyers. Mr. Levine?
I prepared a stipulation that I shared with the defense. If it still makes their approval, I would request that you read both 1 and 2 when the jury comes back into the courtroom, Your Honor.
All right, Mr. Griffith, listen carefully. I've been provided a document entitled Stipulations, and it reads, when parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. This is something that I would be reading to the jury. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are 1. Catherine Griffith is dead, and 2. John Robida, Senior Crime Laboratory Analyst in the Biology Section at the Florida Department of Law Enforcement, performed DNA analysis on fingernail swabbings from Catherine Griffith's right hand and left hand. No DNA results foreign to Catherine Griffith were obtained from the right hand fingernail swabbings from Catherine Griffith. No DNA results foreign to Catherine Griffith were obtained from the left hand fingernail swabbings from Catherine Griffith. Parent, would you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Have you discussed, you can put your hand down, have you discussed this stipulation with your lawyers?
Not in detail, Judge.
No.
Do you want to? Because I'm going to tell you one of these stipulations is an element of first-degree murder and the lesser included offenses of first-degree murder that the state would have to prove beyond a reasonable doubt with evidence absent the stipulation. So that's an important thing that I think you should discuss with your lawyers before you stipulate to it. They may have very good reasons as to why they think it's a good idea, but you need to know why they think it's a good idea. The other things are evidentiary matters that could have some impact on the state's proof in this case, affirmative proof in this case, and perhaps any defense that you might have in this case. So I think you should talk to your lawyers about this for a few minutes.
Yep.
But yes, I was shaking my head no to
And
Jen.
can you tell him, can you take, well, how long do you think you need?
A few minutes.
All right. We just need a couple minutes. He needs to go back there and talk with his lawyers. All right. The purpose of agreeing to that stipulation was?
Yes, sir.
And did they give you some advice on what they thought about stipulating to it and why you should stipulate to it?
Yes, sir.
Did they answer any questions you had about it?
Yes, sir.
Address all your concerns?
Yes, sir.
And do you agree with their proposal to stipulate to these particular facts?
Yes, sir.
All right. And you understand the pros and cons of stipulating to those facts?
I do.
All right. Do you have any questions of me about the stipulation?
No, Your Honor.
And has anyone promised you anything or threatened you to get you to stipulate to these facts?
No, Your Honor.
Including your lawyers?
No, Your Honor.
And you're not currently under the influence of anything, are you?
No, Your Honor.
No medications today, correct?
No, Your Honor.
All right. And you're satisfied with the advice and counsel you've received from your lawyers on whether or not you should stipulate to these facts?
I am.
And you understand the jury will be told, these facts are proven beyond a reasonable doubt, essentially. They don't need any other proof of those facts, and they must accept these facts as true. You understand that?
I do, Your Honor.
And of course, it's for them to decide what to do with those facts and how significant they are. But I will be telling them they have to consider it. You understand that?
Yes, Your Honor.
All right. Anything else you want on the record?
No, sir.
No, Your Honor.
All right. I find that your choice to enter into this stipulation is freely, knowingly, and intelligently made upon the advice of competent counsel. You want me to read this first thing, Mr. Levine?
Yes, please, Your Honor.
All right.
And then Dr. Garavan will be the first witness of the morning.
All right. You may be seated. Good morning, ladies and gentlemen. Welcome back. Thank you for your service. I want to apologize for the delay. I assure you we have all been here at the appointed time working to resolve a legal issue that has arisen in this case. That has been resolved, and we are ready to proceed. I want to advise you that when parties and lawyers agree that certain facts are true, that is called a stipulation of fact. Now, you must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts you must accept as true are as follows. 1. Catherine Griffith is dead. 2. John Robida, Senior Crime Laboratory Analyst, and let me stop you for a moment. I see you writing furiously. This is going to become part of your final instructions, and you will receive a written version of these instructions, and this will be in there word for word. 2. John Robida, Senior Crime Laboratory Analyst in the Biology Section at the Florida Department of Law Enforcement, performed DNA analysis on fingernail swabbings from Catherine Griffith's right hand and left hand. No DNA results foreign to Catherine Griffith were obtained from the right hand fingernail swabbings from Catherine Griffith. No DNA results foreign to Catherine Griffith were obtained from the left hand fingernail swabbings from Catherine Griffith. Mr. Levine?
Thank you, Your Honor. The state calls Dr. Garabin.
Raise your right hand, the clerk has ordered.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth and the truth and nothing but the truth?
Good morning.
Good morning.
Mr. Levine.
Good morning, Dr. Garabin. May you please introduce yourself to the jury and spell your name for the record?
My full name is Dr. David Fintan, Fintan, Garabin, G for golf, A-R-A, V for Victor, A-N.
Tell the jury about your profession.
So I'm currently working in District 10, which is this area, as a medical examiner. A medical examiner is a forensic pathologist. My qualifications start back. I completed my PhD in medical toxicology in 1994 in Trinity College, Dublin, Ireland. I completed medical school in Trinity College, Dublin, Ireland in 1999. I completed mandatory internal medicine and surgical rotations, which is required by our country, before entering into a pathology training program as a specialty, which was 5 years. I completed that in 2006. I started my fellowship in forensic pathology in Miami in 2006. I came here for 1 year, that was 17 years ago. I completed 3 years in different specialties within forensics in Miami, including cardiac, neuropathology and pediatric. I worked in Liverpool, England for 2 years as a forensic pathologist. I took my professional examinations in the Royal College of London in forensic pathology 2010. I then worked in New Zealand and the Pacific Islands for 5 years, travelling around the large country of New Zealand, but I was based in Auckland as a forensic pathologist. I returned to Miami in 2015 as a forensic pathologist. I was there for another 6 or 7 years. I was the deputy chief there for a period, and then I came to Polk County in 3 years ago, I think next month, where I'm working as a forensic pathologist. My other specialties are drugs or toxicology, in addition to forensic pathology.
Doctor, what does forensic pathology deal with?
So there are two types of pathologists. So if you have a lump or a bump or some part that needs to come off you, a biopsy or surgery, that will go to a pathologist, a surgical pathologist, and they will look at that under a microscope and make a tissue diagnosis, which will determine what treatment you have to, if any, that you will have to undergo after. A forensic pathologist will have done that, but we then move on to additional training where we're not looking at parts or biopsies, we're looking at the whole body, and our interest is to determine the cause of death, keeping in mind how natural disease or illnesses affect the human body, how that may cause death or impair the human body, how injuries affect the human body, either on their own or in combination with injury that may cause death to a person, or drugs, the scene, depending on the environment where the body is found, and then the circumstances to a case, whether or not the person was involved in an altercation or not, or whether they were doing drugs or not, or a bit of both, or they were drinking, or they have some disease or illness that may have participated in the injury, the drinking, the drugs, that may provide an explanation to the police. Our purpose is to help police, our jury, or families to understand how somebody has died, or the mechanism, or what were the factors involved. We, in addition to determining the cause of death, we will determine the manner of death. The manner of death is the context within which the death has occurred. It can be natural, accident, suicide, homicide, or undetermined.
What is the definition of a homicide?
From our point of view, the medical point of view is different from a legal point of view. We do not make legal decisions. Our determinations are not the law. The law is a separate matter. But under medical determination of homicide, it means that death has occurred as a result of a violation of some other action. So somebody has done something, or made an action, or have made a series of decisions in an action which have resulted in the death of somebody else. That their action, any reasonable person would know or should have known that action could or should cause the death of another. So homicide is the death result of the actions of another.
Dr. Caravan, as a medical examiner, what are some of your responsibilities here in the 10th Judicial Circuit?
Similar to any other jurisdiction that I work, so our job as medical examiners here, so there are no coroners in Florida. Florida is one of the progressive states. We deal with just medical examiners who are highly trained professional medical doctors who review or are involved in making the decisions if someone needs to undergo an autopsy or not. It is not a decision taken lightly. There's a lot of work done before that decision is made. Autopsies, they're a lot of work. It's not something we do lightly. So there are many ways to do it. We may be contacted by police, we may be contacted by a hospital, we may be contacted by family members, because a death has occurred. By law, all deaths will be referred to us, but the vast majority will not fall under our jurisdiction. They are natural deaths. Somebody has died peacefully at home. It's not unexpected. They're of older age, or they had some condition which is understood that would or could lead to their death. Police have no suspicions, families have no concerns, and that's maybe 95%, 90% of deaths will go down that route. In the other percentage of cases, there's some issue. The death is unexpected. The death was unwitnessed, and there's no particularly obvious reason why they would have died in that moment, in that location. Police may have concerns that the person may have been involved in some incident, altercation, interaction in the days, hours prior to the death, and are wondering if there's some connection. If there's a belief that perhaps some drug or drugs may have been involved, that will fall under our jurisdiction. So if there's issues, particularly legal outstanding issues or concerns from a family, doesn't always mean that somebody has done something bad. It just means that there's an unanswered question, and if we feel that an autopsy would be helpful in answering that question, we will take jurisdiction of the case, and then we will perform. So that's background information first of all. Once we decide we're going to do the autopsy, then there's this broken into several parts. The information review is no different than if you go to your doctor and they have a chart and they have all your medical information in it. They review that information before they examine you. We do exactly the same thing, it's just that you're deceased. So we'll get all that information. I can't ask you questions, but your body can tell me what's been going on. So we'll do an external examination first of all. The external examination will involve looking at you from top to toe, looking for evidence of natural disease or injuries or some clue to tell us that something happened in the environment. Might be electrical burn marks, there could be evidence of drowning, something like that. Then we'll move to the internal examination, where we examine all organs, all major systems, brain, nervous tissue, heart, lungs, and so on. We may choose to take biopsies of all of those tissues to look under the microscope for the presence of natural disease that might provide an explanation as to what's happened. We will take samples for toxicology or biochemistry or microbiology, depending on what's more appropriate for each case, and send them off for testing. When we have all that information back, and it often takes weeks, nothing got to do with us, it just takes weeks for the laboratories to do what they have to do. We will then pull all that information together, taking into account the narrative, the scene, medical examination, the various results. We will then form an opinion as to what was the cause of death and under what context that death took place. So each case takes many hours, and I would do approximately 300 cases a year, autopsies, and I will do external examinations only on probably another 200, and I will review another 600 or 700 that I would decide I'm not doing anything with. So that's how many cases we would be constantly dealing with.
The external examination of a deceased individual sounds pretty obvious, but how do you do the internal examination?
The internal examination it's an intrusive procedure, and we're aware of that. That's why we don't make the decision lightly. It requires that we have to open the body. You have to open the chest, the abdomen, the head, look into the pelvis, which is part of the abdomen examination. And if we need to do, there are many other specialist tests that we can do if we need to, which would require further intrusive methods, but they're done with as much skill as we can, so that when the bodies are returned to the families, that all of that's hidden. That's out of view. We try to close it up so that you wouldn't know the difference. But it is a very involved procedure. It's manual, it's not easy work, and it's tiring.
Now, in the normal course of an autopsy, are photographs taken of the deceased victim, both internally and externally?
Yes.
And in this particular case, I'm going to have the opportunity to show you State Exhibits 125 to 155 a little bit later. Will that be helpful for you to be able to point out and explain some of the injuries and some of your findings that Kathy Griffith suffered?
Yes.
Now, in this particular case, the death happened on a Sunday, September 8th. Describe to the jury the process by which you receive the body and when you typically conduct an autopsy.
So the only reason why this case is with me is because that was my week. There's no other reason. We work on rotations. So I would have first met this case on Monday morning. I would not necessarily have heard about it on the Sunday. I don't remember, to be honest with you. I just don't. So when I went in on Monday morning, her name plus other names were on that list that morning, and that's the first time I would get to read the police report to find out that's the beginning of the narrative. In all homicide cases, please do attend those cases, the investigating detectives, which is very useful because then I can have a much more one-to-one conversation. So that's where I would have got my information.
Do you work for the State Attorney's Office? Do you work for me?
I do not.
Do you work for law enforcement?
I do not.
Who do you work for?
I work for the public.
All right, Dr. Garvin, the autopsy that you performed on Catherine Griffith, describe to the jury a little bit about the room or operating location where you do your autopsy.
So our autopsy suite is it's a custom built place. It's got two stations where we can conduct our examinations. We tend to use one. It's an open. It's no different from an operating area. We don't have to have the high clean room specifications of an operating theatre, but it's no different. There's a table and there's ventilation and there's instruments and they're all laid out and so on and so forth. So it would look quite similar to an operating table.
Now, before we get to the cause of death and the manner of death towards the end of your testimony, I want to ask you about your autopsy findings. What can you tell the jury about the injuries that Kathy Griffith suffered?
Do you want me to go through all of them in detail or just a summary?
First, we can start with a summary.
So the autopsy findings are a sharp force injury to the right side of the neck, bruising to her lower limbs, bruising to the posterior right shoulder, left elbow, back of both hands. There was an incised wound, and I'm going to explain the difference between an incised wound and a stab wound in a second, between her thumb and index finger of the right hand. So here there's an incised wound that was 1.5 centimeters. It was gaping if you open the hand, so 1 centimeter. A stab wound is a wound that is deeper than it is longer on the surface. An incised wound is a sharp force injury as well, that's longer on the surface than it is deeper. They're the opposite. So in an incised wound, the sharp blade or the sharp surface has come across the skin, but has not gone deep into it. A stab wound is the opposite. It's penetrated and gone into the actual tissue.
Was that gaping incised wound, was that a fresh wound?
Yes.
And describe to the jury why that is.
Because there's no evidence of healing. It's gaping, it's opened, and you have dry blood in it.
Now, is that gaping incised wound consistent with being a defensive wound?
It's possible that, defensive wounds are, so that's a term that's used, and I know it's thrown around a lot. We personally don't write down classic for defensive wound because we don't know precisely what the circumstances of it happened. But let me explain what the greater points of a defensive wound are. Defensive wounds is a term that's used when there's a series of injuries that can be bruises, can be incised wounds, it can be any other cuts or abrasions that are present on certain locations. And the reason why there's certain locations is that you have to understand that fundamentally the human will or the human body is designed to survive. Everything about us when we're under attack, when we're in a fight or flight situation, regardless of the circumstance, that if the human person is conscious enough to understand that they're in a struggle for their life for whatever reason, they will engage in activities which will try to help them survive. If you're under attack from an assailant, it is quite typical if the person is swinging something at you, baseball bat, fist, whatever, you will tend to try and protect yourself. And in doing so, certain parts of your body become exposed to that force that's coming at you as you try to defend yourself. In the arms, it's typically here. If it's a bat or a stick or something that's coming at you, they may also be on the legs. Typically, and it's more common in women if they're being attacked, but it happens in men too, they will tend to offer the outside of the leg as they're trying to protect their sexual organs, or they're trying to protect themselves if they're under attack. So we will often find wounds on the outside of the legs, not the inside. In knife injuries, when somebody's under attack where there's a knife or a sharp implement involved, it's common that the person, unfortunately, mistakenly, will try to grab that knife thinking that this is somehow going to be of help to them. It isn't really, generally, but in doing so, if they grab that blade and then that blade is pulled, you'll often find incised wounds across the palm of the hand, or it can be here, depending on how the knife is grabbed. Or it could very well be that as the hand goes up to defend against the oncoming blade, that blade just comes through here and then cuts as it comes through. Because I don't know specifically, we don't have a video of how exactly those injuries occurred. We tend not to use that term, defensive injuries, but that is what's meant by them. They're present in certain locations under certain circumstances that may indicate that the person who's now deceased was trying to defend themselves at the time of the assault.
Now, you mentioned that Kathy had bruises on her upper and lower limbs. Does that mean arms and legs?
Yeah, so again, I know it seems a bit impersonal, but we say the lower limbs and the upper limbs because we're talking about the whole arm. When we want to talk more specifically, we tend to use the anatomical location, whether or not it's the anterior elbow or the posterior forearm or whatever it might be. But upper limb is the entire limb from here to the fingers.
What were you able to determine about the bruises on Kathy regarding whether they were old bruises or new bruises or a combination?
Yeah, so so dating of bruises is not it's not an exact science. We do not, TV shows I know do that all the time. That's not reality. What I can say is that these bruises, there were quite a number of them present. All we can say about bruises is that if the colour yellow is present, we can say that it's definitely not, there wasn't an immediate before death bruise, because yellow would suggest that at least 15, 16, 17 hours has passed since that bruise was present. It could be weeks, but at least 17 or 18 hours has passed. That's the best we can do in reality. But all these bruises in this particular case did look fresh in that there was no colour change. It doesn't look like they had gone or had the opportunity. The person wasn't alive long enough for the body to try and heal or start healing a bruise. So that's the best I can say to you.
Dr. Garavan, before we get to the photographs, how can you describe Kathy's neck wound to the right side of her neck?
So the wound on the right side of the neck is a large stab wound. It's gaping, and gaping means that it's an obvious. Once you see it, it can't be anything else. It's an open wound. It was 4.3 centimeters long and 1 centimeter apart. It's 2.5 centimeters right off the midline, so approximately here, and 23 centimeters from the top of her head. So we do that just to give you an anatomical location. So approximately here on her neck is where it was. The wound is in a 9 to 3 o'clock orientation, meaning that if you look at a clock, 9 to 3 means it's kind of looking straight when the body's in the right, so it's coming straight across here. And there's a square edge to the 9 o'clock margin. That's important, because the square edge suggests to me that it's a single blade, not a double blade. That is the knife or the blade that's been used to cause. So there are characteristics of a knife wound which help us determine if it's a single blade or a double blade. And in this case, it would suggest the blade was single bladed. So the wound then goes into the neck. It travels from a front to back, so it's coming in from the front and heading towards the back. It's travelling right to left, and in doing so, and it has gone through. So the esophagus, the food pipe, has gone through the trachea, the windpipe, and it's just above the vocal cord. So it's transected the trachea right across, and the food pipe. And the blade continues so that the top of the blade came out the other side. So there's a small sharp force injury on this side. It's 0.6 by 0.2, so quite small, but it shows that the tip of the blade met it all the way across and poked out the side.
What type of force is necessary for the knife not to just enter the body, but to do all that traveling that you mentioned and actually go out the other side of her neck?
We often get asked this question. In fact, we always get asked this question: how much force is required? We don't know, right? we don't have the ability to be there to measure newtons, pounds per square inch or whatever. But what we can tell you is that one of the major qualities, the most influential quality of how easy a knife will penetrate the human body is the tip of the knife. The tip of the knife, once it punctures or penetrates the human skin, it's relatively easy for the knife to then enter because our organs and our tissue they don't offer much resistance. So I can't tell you how much force was used, but I can tell you it can be surprisingly not as much required as you might think. However, in this case, it's gone through the trachea. The trachea is a tougher organ or tissue. It's got cartilage in it, so it would require the application of some pressure for it to continue to the other side. But I can't tell you in pounds per square inch how much that pressure is.
Now, have you had the opportunity to conduct autopsies on multiple stab wound victims over your years?
I've done many hundreds.
And do you see any consistencies amongst those in terms of the nature of the injury or the cause of the injury?
Well, I've seen all kinds. Homicides, I've seen suicides. I don't believe I've come across any accidents, but I've seen suicides. Certainly people have used knives to take their own life, but the vast majority would be homicides.
All right, so the vast majority are homicides. You've seen some suicides, but no accidents, correct?
Not to my knowledge, no.
All right, Dr. Girvan, I'm going to show you some photographs, and hopefully it shows up on your screen. And if I have some questions about them, of course I'll be asking you some questions. So, starting with 126, is this how the body comes to you?
Yes.
127, 128. During your autopsy, were you able to determine the victim's weight and height?
Yes.
What were those stats?
She was 5'2" and 126 pounds.
Is that a picture of the stab wound?
Yes, as the body arrived before it's cleaned, yes. That's the same wound after it's been cleaned.
Now, you mentioned the gaping wound and the definition being wide open. What is it that we're actually seeing once you get past into the hole there?
You're looking at the internal structures of the neck. So the head is back, so it obviously pulls on it to make it gape more, but there are other reasons. It's a lot more details to it. So there are things called the lines of Langerhans. When you're all young and pretty, of course, you won't know about these lines of Langerhans because your skin is nice and tight and there's no wrinkles. But as we get older, the lines of Langerhans begin to take over, and they are a natural tension line that's present in all our skin. And if we cut across the lines of Langerhans, you may be familiar with the grain of meat, then the wound are gaping. But if we cut in the same direction of the lines, which surgeons will always try and do, because then the scar will be a lot less obvious. In the neck, they are roughly coming down the neck in a straight line, so this wound has gone across them. So those lines are now apart, and that makes it gape more than if the wound was the other direction, between 12 and 6.
So in this picture...
I would like for you to know, if you need it, that mouse over there operates as a pointer.
Oh, yeah, thank you. Actually, I didn't know that, but thank you.
Could you please point with the mouse and the red arrow? Where's the visible organ within her neck?
So in here, you can see that there's a structure present here. This is probably part of the larynx, probably part of it, but clearly it's a gaping wound, and you can see that there is a structure inside here. I think it's part of the larynx from looking straight in, but I'm not entirely sure. That's part of where the voice box or the larynx has been transected, so it's cut open. That should be a whole piece. It shouldn't be separated like that.
Now, in order for the end result to be the death, what happens physiologically after that knife does all that damage?
Yeah, there's a couple of things. So the human neck is extremely vulnerable. It's probably the most vulnerable part of our body. So once a knife goes in, not only are there your windpipe, your food pipe, there's also a lot of arteries which conduct a lot of blood, but there are also several nerves that are traveling through the neck, the vagus nerve, the phrenic nerve, and so on, and they're coming down. If we transect them, there's immediate implications, clearly. The vagus nerve supplies the heart, and the phrenic nerve supplies the diaphragm to which you need to breathe. It has to have that bellow effect. So if they're transected, then they're not available to you anymore. So you have a combination of bleeding and severing of nerves combined will bring a rapid death.
Is the bleeding both external and internal?
I would expect this to be a bloody scene, yes.
(132). Is there any different parts of the organ visible in this picture?
No.
All right, now we continue 133. What's that there?
So that's the exit of the tip of the knife. So the tip of the knife has come all the way across the neck and has poked out here.
Is that a close-up of the exit wound?
Yes.
Now, there's a metal rod there. Describe to us what you were doing here.
So in all gunshot wounds and in stab wounds where possible, we will put in probes to show the direction that the wound is travelling in. So in this case, it's travelling right to left, upwards, front to back, and that probe is following the path, the same path that the knife followed.
What can you tell us about 137, Dr. Griffith?
So this is the internal examination. I've taken out the neck structures. You are looking at the neck from behind. So here is the epiglottis, this is the tongue, and this is the esophagus that's open, and the trachea is underneath it. It will be, this is the epiglottis, this is the posterior surface of the larynx, and here the blade has gone through the upper part of the esophagus, as I'm pointing out there. So this fold and this fold connect, so this would be a tube. The lumen here is your food pipe. I've opened it to show you that the blade travelled through the esophagus, which has transected the esophagus, or perforated, I should say, the esophagus.
138, what do we begin to see here?
So this is the right hand, and you can see there's a bruise here, and it's not well shown in this picture, but this is where the incised wound between the thumb and the index finger is. There's some bruising down here also at the bottom. This is the index, this is the thumb and the index finger of the right hand, and this is that incised wound that I talked about. So it is longer on the surface than it is penetrating, and it's from a sharp force injury, I suspect, from a blade.
Going back to, you mentioned the bruising. So due to the color of that bruising, does that coincide with what you were saying are more fresh bruises on Kathy?
Yeah, these do not look as if they have had time to heal or undergo the healing process.
All right, what can you tell us about 141, Doctor?
This is her left upper arm, and there's some bruising here, there's some bruising on the elbows. These are abrasions, but they are not injuries. These are post-mortem. There are differences. They happen after death, and it's got to do with many other things, but they're commonly often misinterpreted as injuries. They are not, due to their yellow, parchment-like colour. And I can appreciate if you don't see it, but there are actually small veins running through the bottom there, and that's quintessential of post-mortem, not an injury. But there are injuries, and the injuries are here, the elbow, and up here just at the biceps, and down here.
Continue on with the close-up, and we continue with some additional photos. Now we have 143. What appears to be on the wrist area and the hand?
Yeah, so this is the left. It looks like the left upper arm. So there's that bicep bruise, and this is heavy enough bruising present on the posterior wrist and hand. Some small bruising here also.
Is that another view of it, different angle?
Yeah, and there's also just another bruise there on the back of the little finger. That's the left hand also, and the left arm, and there's some bruising here.
Can bruising be caused by if somebody grabs somebody real tightly?
Bruises, by definition, it's better to just go with the definition, and then you can work it out thereafter. So in our forensic pathology, a bruise is where blood has escaped into the soft tissue due to blunt force trauma, not due to a sharp force injury, not due to a bullet wound. It's due to blunt force trauma. What the blunt force trauma is can be a whole range of things. It could be grabbing, it could be punching, it could be falling, it could be kicking, but it's blunt force trauma.
All right, thank you, Doctor. What do we see here?
This is the other arm, that's the right arm, and there's a bruise across the triceps here. Right elbow, more bruising. Back of the right hand, I think that's the right hand, it is, yeah. And there's some bruising there on the back of it, and up here on the back of the index finger of the right hand. That's a small abrasion, minor abrasion on the right shin, by the look, yes, the right shin. You can see bruising here at the back of the left, this is the left calf. There's some bruising here on the anterior shin, here, here, here. this is an abrasion along here. So an abrasion is just your definition. So a bruising is the escape of blood into surrounding tissue. An abrasion is due to blunt force trauma, but is confined to the epidermis. So the outer layer of skin is the epidermis. So as something rubs across that for whatever reason, blunt force, comes across the skin and pulls or rips or tears that epidermis, that's an abrasion. Okay, and they're only due to blunt force trauma typically.
And the last few photographs, Doctor.
This is an abrasion, but I suspect that's post-mortem. I would not probably call that an injury. That's an injury. That's an abrasion. That's a skipped-like abrasion, incomplete abrasion. So something, whatever has caused this, either it has skipped along the skin or it itself was not fully in contact with the skin as it was rubbed across the skin, causing the abrasion. Bruising is present on the forearm, here and here.
Now, from your conducting the autopsy and your training and experience, what was the cause of death?
So the cause of death is stab wound of the right neck.
And what was the manner of death?
In this case, the manner of death is homicide.
And when you say the manner of death is homicide, what does that mean?
So with the information that would have been provided to me at the time, and with the examination and what I've viewed and witnessed and reviewed, the explanation for this death is that this wound was inflicted by another person.
So is it a fair statement that it is not consistent with somebody accidentally falling on a knife?
I haven't been given that explanation before, but I think that would be rather extraordinary. No, I don't believe so.
So your end result was that the manner of death was a homicide, a killing caused by somebody else, correct?
Correct, yeah.
All right, Dr. Garavan, I have no further questions.
Thank you.
Cross?
Good morning, Doctor.
Morning.
Dr. Garavan, I want to talk about injuries that can result from mutual combat or a fight where two people are mutually involved in a struggle, whatever. They can be very messy, correct?
Well, I suppose mutual combat, mortal combat, could very well be messy depending on the circumstance, yes.
Well, if any two people, regardless of size, strength, etc., are involved in a fight, both can receive injuries, correct?
Yes.
And both can receive what you've termed defensive wounds, even though that's not a term of art, it's sort of a vague term. But
Yes.
you would agree that both could receive those types of wounds?
Yes.
And you would agree that both could also suffer offensive wounds in such mutual combat?
Yes.
And even if somebody suffers a wound that ends up leading to their death, you don't know from your evaluation what happened leading up to that wound, correct?
So depending on the information provided by police, so I am given some information, but it depends in each case. Sometimes we know nothing, but in this case I knew something.
Right, and then the information that you get from police is their interpretation of things, correct?
Yeah, I rely upon them. That's how it works. I rely on the information they give me. Yes, that's correct.
And so if they don't give you all of the information that they have, then you might be lacking some critical piece of information in making your determination.
I'd be very disappointed if that happened, but yes, you are technically correct if I'm not given all the information.
Do you also look at media accounts of what allegedly occurred?
I
that
do
led to
not
the death?
watch the news. I have no media. I have no social media. God, no. I have better things to do with my time.
So this is a weird question then. Why does the medical examiner's file in this case contain multiple media reports?
The secretaries in the office will do that as part of the thing, but I only saw them yesterday for the first time, and I don't read them. But it's common practice around the world. I've been in other offices. People do that, but it's nothing got to do with me.
Okay, just checking.
Yeah.
But basically, you cannot say what happened in the kitchen where Catherine Griffith suffered this wound, can you?
Well, I can certainly say that she suffered a fatal stab wound or has suffered fatal injuries, and based on the information provided to me at the time, that the most likely determination, excuse me, is that she's died from the action of another person, therefore a homicide.
But you can't say, for example, whether Catherine Griffith attacked the other person with a knife first, right?
No.
Okay. And you don't know how everybody was positioned or whether there was a struggle over the knife or anything like that?
Not in this case. Sometimes we do, but not in this case. I did not have that detail of information.
Speaking about the bruises that you've shown the jury, those could be up to several days old, couldn't they?
So dating a bruise is tricky. There's no argument there. But in this case, I wouldn't say days, but could they have been present a couple of hours before the incident? I can't tell you.
Okay. And bruises such as we saw on the photos could happen from somebody bumping into something?
Yeah, absolutely. I mean, people can bruise very easily. You always get a bit concerned when there's a lot of them, and there are a lot of them. And I wasn't provided with an explanation other than a confrontation that might provide an explanation for them.
What about from doing innocuous activities like housework or things like that?
Also, yeah, it's entirely possible, and again, you would take that into account if it's as you are now, and that's perfectly fine. And yes, people can get bruises doing innocuous things, but the thing about innocuous things is that they tend to be very few bruises. They tend to be confined to one particular place, depending on what they were doing. And in this case, there's a lot of bruises, and they're in a lot of locations. So if you can give me the innocuous thing they were doing, I would consider it. But otherwise, for me, it more likely than not would be better explained being received during a confrontation.
A confrontation that could have been mutual combat.
Yeah, absolutely, a violent confrontation for whatever reason.
Can you say whether somebody who has rheumatoid arthritis might bruise more easily than someone who doesn't?
It's not something I'm aware of as being a thing, but if they're taking if they're on a lot of steroids as part of the treatment, people on steroids do bruise easier.
Was there any way for you to determine whether Catherine Griffith was taking steroids for rheumatoid arthritis?
So wasn't aware that she was taking steroids, wasn't asked about that, and even if it was, to test for steroids is extraordinarily difficult. There are very few places in the world that do it, and even if you do it and you find steroid is present and you know she's taking it, I haven't proved anything. So if somebody tells me she's taking it, that's fine, but I wasn't told that.
Right, and I'm not suggesting that that's something that you normally would have been aware of, given the fact that the autopsy happened the day after she died and you spoke with law enforcement, not family members, right?
Correct.
Right. I'm just asking about that possibility.
Sure, yeah.
In your training and experience, have you ever observed bruises that are clearly made from, say, a hand or fingers?
Yes.
So if somebody's grabbing somebody's arm,
Yes.
like I'm showing, so fingers around the arm, you would expect to see bruising that resembles the shape of the fingers.
It can do. They have a name. They're called discoid bruises, meaning looks like the pads of your finger. It can happen, and certainly I have seen them, particularly in young women that have died by strangulation. You can see, it's not in every case, but you can see the hallmarks of what look like fingertips or somebody was grabbed by the neck by their fingers. It's also possible that if a person is strong enough and the other person is small enough, you can get similar discoid-like bruises. There's nothing about the bruise that screams at you, this is a fingertip. But what you can do is that if somebody says, could that be a fingertip? Then you can say, yes, that could be a fingertip.
Did you notice any of those types of bruises on Catherine Griffith?
Nothing that would have jumped out at me as specifically that.
You've mentioned that the neck is a particularly vulnerable spot on the human body. There was no bone involved in this stab wound, was there?
It did not go through the cervical spine, no.
Okay, so it went through soft tissue, basically.
Soft tissue and trachea, which is cartilage. It's a little firmer, but yeah, it's not a whole lot, but it's a little firmer.
And so far as you know, there was no clothing or any object over the Catherine Griffith's neck to also provide, say, a layer of protection beyond her own skin.
I'm not aware if there was. Yeah, I didn't see any. I wasn't told about it.
You mentioned that the cartilage is a little bit tougher than some of the other soft tissue that the knife went through. And maybe this is crazy, but explain what a tracheotomy is.
So tracheotomy, you're talking about in emergency situations, I'm not trying to be facetious, but a cricot tracheotomy, a cricothoracic tracheotomy. If you're in an emergency situation, the person's airway is compromised for whatever reason, a crushing injury or something is blocking the airway, and you need to get air into the airway, so you bypass the blockage. So you find the Adam's apple,
Which is the trachea, right?
Which is the voice box. It's the front of the voice box, more prominent in males than females. But then you come down approximately one finger, but as you rub there, you feel a little dip. It's very subtle, but you feel it. And that's where you want to make your incision. But that's not going through cartilage, it's going through this soft tissue in between.
My mistake. You mentioned in your direct testimony that you can't say with any certainty what level of force was necessary to make this wound.
No, I can't give you a number. No.
And you said that the But you are aware that there are some variables that can give us some information about the level of force.
Yep.
If you're looking at a spectrum from very little to a whole lot.
Yeah, they are, but from my point of view, it's the tip of the blade that really, once the tip of the blade overcomes the skin, the greatest resistance is from the skin.
Correct.
And once you get over that, you'd be surprised how little actually is involved. But that doesn't mean that the person wasn't using a lot of force. It just means I can't tell you.
Right, I understand. And in this particular case, the tip of the knife that caused this wound was triangular in shape. Are you aware of that?
I don't believe the knife was shown to me. I wasn't brought the knife from memory, at least. Look, I've seen so many cases since in between. I might be missing, but I think I may have seen a photograph of the knife.
So, what is it? Your understanding that it was a triangular tip?
Yeah, like a typical kitchen large carving knife, I guess is what I would call it. Yeah.
And would you agree that that type of tip is actually geometrically speaking, is the easiest to penetrate the skin with?
Yeah, so that's a sharp tip, and that once it penetrates the skin, you don't anticipate much more force being required for it to continue in.
I want to ask you a question about the toxicology in this case. I know you personally did not perform the toxicology tests, but you received the results of the toxicology tests on Catherine Griffith's blood, right?
Yes, correct. We take the samples, they're sent to a toxicology laboratory. It's a whole different world. They live in a different place, but they're the ones who do the testing. It's up to us to do the interpretation.
Right, and in this particular case, while you didn't find that the toxicology results contributed to Catherine Griffith's death, there were some drugs in her system that you were at least concerned enough to note in your report, right?
Yeah, I wouldn't say I'd use the word concern. I'm kind of obligated to tell the truth, and if they're in the report, I've got to report that. I can't hide it. But there were 2 drugs present, that is correct.
Okay, what were the drugs?
One drug is called alprazolam, you might know it as Xanax, and the other drug is amphetamine.
Okay, tell the jury about alprazolam.
So I'm sure I'd be surprised if you haven't heard about Xanax. It's a drug which is given, is widely abused by many people, but it's a legitimate drug. It's prescribed. Typically, it's belong to a class of drugs similar to Valium. It's a benzodiazepine, and it's used typically for anxiety. People who are prone to anxiety or have anxiety. It can be used for other reasons, but that's the main reason. People who who have symptoms or signs of anxiety. They might be, heartbeat, racing heartbeat, chest palpitations, whatever the case may be, not sleeping well. Typically, Xanax can be prescribed for that.
As far as some of the side effects that could occur from alprazolam, do some of those side effects, although they might be rare, include racing thoughts?
Yeah, it's like any drug. No drug is perfect. Some drugs, they can have strange side effects. It's true. Can Xanax cause the opposite almost of what it's designed to do? Like any drug, that can happen. It would be very rare, but it can happen.
What about agitation? Can Xanax cause agitation?
Oddly enough, it's paradoxical. It's given for agitation, so why would it be causing it? In very rare cases, it's been known to happen.
And what about risk-taking behavior? Can it also cause that?
Risk-taking behavior. What do you mean by risk-taking behavior?
That's just what the literature said. That's the term I'm asking about. And it can be interpreted many different ways.
Yeah, it can. Yeah, it is a drug. It is a drug that's commonly abused, I suppose. So if people are using it in an abusive manner, that's not the medical reason why they were taking it or the reason why they prescribed it. So I'm not sure what risk-taking behavior is, but it can be abused or misused.
You have no idea whether Catherine Griffith had a valid prescription for Xanax.
I do not.
The amount that was in her blood could have been well above a therapeutic dose that a doctor would prescribe, correct?
Tricky one to answer,
Yes.
because Xanax is, like most other benzodiazepines, is a drug that's subject to what's called tolerance. What does that mean? Simply put, if any of you drink alcohol, you probably noticed that the first time you drank alcohol it had a certain effect on you, but as you continue to drink and get older, you seem to need more of the alcohol to get the same effect. That's tolerance. So you need more of the drug for it to do the same thing. Xanax is certainly prone to that. So looking at a blood level in a post-mortem setting doesn't tell you a lot about whether that person was taking too much or it's had an effect on them, or this could be her normal. This could be just the amount she needs to have to be on a steady keel. Maybe it was a lot higher in the day. This is just a snapshot of what we caught. There's also another reason to make it complicated for you. I mean, it does take a while to get through all of this. there's a thing called post-mortem redistribution, okay, and that is a circumstance where if you take a certain drug or certain drugs for long enough in your life, you would think that they go in, circulate around your blood, and then the body gets rid of them. Not true. Right? If you take certain drugs long enough, the body goes in, circulate around the blood, and then there's part of them are stored, sequestered, like a jury is sequestered in a room, and they're not available to the body, but they've dissolved in the fatty tissues, or they've dissolved in other compartments of our body, which is water, fat, protein, and so on. And then after death, when you die, those stores are released, and they go back into the blood. Some of them do. So sometimes the blood result you're looking at is actually higher than it would have been when she was alive, or anybody was alive. So it's another factor we have to take into account, and Xanax is one of those drugs. So depending on how long and how much she was taken, this 27 could be a little higher than what it would have been at the time of her death. But in any event, it is not at a level that would concern me that it participated in her death, that it would have impaired her beyond some extraordinary means. It's almost, if you're doing enough of these cases long enough, 27 is not high, and it wouldn't concern me personally.
Okay. But it could be above a therapeutic dose that a doctor prescribed to her.
Yeah, so again, for the same reason I've just explained,
Yeah.
therapeutic, we can't use the terms therapeutic because we're not dealing with a therapeutic situation because it's post-mortem. And secondly, I don't know how much she's being prescribed or how
Or
much
if
she's
she's
taken.
been prescribed.
Or even if she is being prescribed. Correct. I don't know that.
Okay. So then let's go to the amphetamine. What is amphetamine?
So amphetamine is a stimulant drug. It's belonged to the amphetamine class. It's a subclass of another division of drugs called the phenylethylamines, of which that's an entirely large family. But amphetamines have been around for quite a while, maybe late 1800s, early 1900s. They really became into their own in probably World War II, when the German army figured out that by giving them to the soldiers that they needed less food and they could stay awake longer because they were running out of men. So they needed the few men to have. So they were given, Hitler famously was partly one of the many drugs he was taking was an amphetamine. So they've been around a long time.
So basically it's what some people refer to as speed or an upper.
It's an upper. It's a stimulant. It activates the nervous system to reduce tiredness or appetite and to stimulate the sensation of being awake.
Which is sort of the opposite of what a benzodiazepine or alprazolam is designed to do.
Yes.
Right? Okay. Amphetamines can cause side effects such as erratic behavior
Yes.
and sometimes even violence.
Any stimulant can be associated with violent behavior in certain people at certain times, yes.
And Catherine Griffith had both amphetamines and alprazolam in her blood.
Yep, the amphetamine is reported at less than 0.1 milligram per litre, which is about 100 nanograms per mil. It's a very, very low amount, but it's there.
Do you know if she had been prescribed amphetamines?
I do not know that.
I don't have any other questions.
Thank you.
Thank you. Redirect.
Just briefly, Your Honor. Doctor, could you tell the jury about amphetamines being prescribed for like a legal prescription? What would be an example of that to treat what?
Yeah, so amphetamines are prescribed, can be prescribed. The more common one is ADHD. So typically, there are several formulas available on the commercial market. So that's one, and the other one that I know of is narcolepsy. People who suffer from sudden bouts of falling asleep can be prescribed amphetamine. So there are genuine, legitimate reasons why somebody may have it in their bloodstream.
The two substances in Catherine Griffith's toxicology results, is it a fair statement they have nothing to do with their cause of death or manner of death?
I don't believe so, no.
All right, I have no further questions for you, Doctor. Thank you.
Thank you. Is he released?
Yes, sir.
Sworn in?
Yes, sir.
Thank you,
Thank you,
Doctor.
John. Thank you. Thank you.
All right, ladies and gentlemen, it's just past 10:30. We'll go ahead and take our mid-morning recess of 15 minutes.
All rise, please. May I be seated?
Thank you for the break, Mr. Levine.
Your Honor, I have the next witness is going to be Robert Volantis. I have instructed him that he is through the court's ruling and order that he is not to mention in any way, shape, or form that the defendant killed his dad. So that will not be elicited from me. He understands that. But in an abundance of caution, if perhaps Your Honor could instruct him outside the presence of the jury.
Mr. Lee, do you mean you're not even going to ask him about that incident at all, or he just needs to know he can't say it was the defendant's father or relative?
Well, if I remember correctly, Your Honor.
I don't know what you intend to present, is why I'm asking that.
Yes, if I remember correctly, and please correct me if I'm wrong, but I believe Your Honor ruled that he could not mention that the defendant told him that the killing in Oklahoma was not an accident, that it was planned, even without mentioning that it was the defendant's dad that he killed. That's my understanding of the ruling. So that if that wasn't a ruling, then I would ask him that.
I think that was my ruling, but I didn't know what other
Correct.
information he might have that's adjacent to that. So,
Gotcha. No, I will not be asking him anything about the killing in Oklahoma, and he understands that. But once again, where we are in the trial, which is coming in the home stretch of the state's case, and to ensure the integrity of not getting a mistrial, I would request that you order to not discuss that.
And I wholeheartedly agree with Mr. Levine's suggestion to speak with him outside of the jury.
let's do that when I get back, so it's as fresh in his mind before he's called to the stand.
Very good. Thank you, Your Honor.
Before Mr. Molantis leaves,
Yes.
that if there is going to be a question such as while Collin was living with his dad in Oklahoma, it sounds like the rest of that question might be, did Kathy have much contact with him? And that, the basis of that objection to that would be hearsay, because he doesn't know that. He would have been told that by Kathy. So, like I said, I'm guessing at what the second part of that possible question might be, but I'm worried that...
Levine, is that where you were going?
No, Your Honor. My question will be something to the effect of, did the defendant live with his father in Oklahoma for a few years while Kathy remained in Florida?
All right. Thank you, sir. All right, we're ready for the jury.
All right, ladies.
You may be seated. Mr. Levine, state's next witness.
Your Honor, the state calls Robert Wolantis.
Stand this way, please. Can you read your right hand? Raise your hand.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Good morning, sir.
Good morning, Judge.
Mr. Levine.
Thank you, Your Honor. Good morning, Mr. Volantis. May you please introduce yourself to the jury and spell your name for the record?
Good morning, ladies and gentlemen of the jury. My name is Robert Wolantis. Robert, R-O-B-E-R-T, Wolantis, W-A-L-A-N-T-A-S.
One says Continental Divide.
It is. That's in eastern New Mexico.
And then,
I'm holding up the other side of the sign.
all right. Did the sign fall down or not?
We held it in place. Kathy and I did a good job that day.
All right. What about 183?
That is Kathy with a huge log of petrified forest. And that is the largest meteorite, or a piece of a meteor, that impacted in Arizona.
And then final photograph?
That is my birth mother, and Kathy and I. So we have 3 generations there. That was for her 90th birthday.
All right. Now, Mr. Volantis, when the defendant moved back to Florida to live with Kathy, was Kathy happy about that?
She was thrilled.
Now, during the time period when, like, since then, when he moved back to Florida and lived with her, did she try to make up for lost time?
She did.
And what were some of the activities that she and your grandson would do?
They had to catch up on 3 years of school. Collin was 3 years behind. And then they also caught up on the 4th year. So he got 4 years of education done in a single year. That's a huge accomplishment. They went to Australia, Central America, the Caribbean. She wanted to give him...
Now, Mr. Volantis, what was your daughter's profession?
She was a teacher.
And what subject matter did she teach?
Mainly English, but she would do other humanities as well.
Now, tell briefly to the jury about your relationship with your grandson. Did you have a relationship with the defendant?
We would talk on the phone, but I'm not a helicopter parent. I was there to support him and to support Kathy and to love them and be there for them.
Based upon your personal observations, did it appear that the defendant trusted you and would talk to you and confide in you about certain things, grandfather, grandson, topics?
Yes.
Did there come a time when the defendant said something to you that was very disturbing to you?
Yes.
Tell the jury about what the defendant said to you.
My grandson was very aggravated at his grandmother and his mother. He said, "I am so tired of these 2 bitches. I'm disgusted." He said, "My mom, I keep thinking over and over, I want to slit her throat. I want her to bleed out. I want to smell the blood. I want to feel the blood. I want to feel the life and the blood leaving her body."
Now, when he said that, what went through your mind?
I needed to take a deep breath and do what I could to discourage that thought, because thoughts become words, words become actions.
What did you say to him in response?
I said, "Collin, I love you, buddy, but you can't have those kinds of thoughts and focus on them and then speak them, because you will cause them to become reality. Please think positive things about your mom, about yourself, and about a good future together."
Now, at any point, did you warn your daughter about what the defendant was wanting to do to her?
I did, but I did not use the exact words because there was so much malice.
Objection, Judge.
Now, explain to the jury, were you concerned that if you used the exact words the defendant said that he wanted to do to his mom, that might negatively affect their mother-son relationship?
It would, and I was afraid it would actually give her nightmares.
Did you tell her a clean version or a more vanilla version, if you will?
Yes, I did.
What was her response?
That he's been threatening her, and he's been threatening Susan multiple times with killing both of them.
Now, knowing that, though, did you still want him in the household and wanted to keep having the relationship with him?
Yes.
Mr. Wolantis, I don't have any other questions for you.
Thank you, Cross.
Good morning, sir.
Good morning.
Mr. Willantis, you didn't come to Kathy's funeral, did you?
No.
Can you explain why?
The funeral for a person is for those left behind. I will see Kathy in my thoughts, in my mind. That's where I want to keep her. Attending a funeral where her body is placed in the ground, that's not Kathy. Kathy's spirit is elsewhere. The essence of Kathy is elsewhere. She's with me. She's here in this room today with each of you. She can speak to you. She can speak to me.
Mr. Willantis,
Ma'am?
I asked whether you went to the funeral and why. Just answer that question, please.
You interrupted me as I was explaining why. That you don't like my response, ma'am, that's your problem.
Judge, would you please?
If you would avoid the commentary and you've asked the question.
I did ask the question, but then he's talking about her being present and speaking to the jury, which is non-responsive.
Sustained as to non-responsive, that portion.
Mr. Willantis, the picture showed a trip that you took with Kathy. That was one trip, right?
That's correct.
Have you taken any such trips with any of your other children?
No.
Do you have memory problems, Mr. Willantis?
With what, ma'am?
Just in general.
Oh, sometimes I might think it was something that occurred a week ago, and it's actually a week and a half ago.
Okay. But that's the extent of your memory problems?
Usually, yes.
When was it that you say Collin told you that he wanted to slit his mother's throat?
I believe it was 4 months before she was murdered. It may have been before that.
And, Judge, I'm going to ask that he be instructed not to use terms like that. That's for the jury to decide.
All right. Ladies and gentlemen, it is up to you to decide whether or not there was a murder in this case. You'll disregard that, the use of that word.
Mr. Willantis, please tell us the month, if you remember, that Collin supposedly told you the things that you've shared with the jury today.
May
May of what year?
2024.
Okay. And how did he tell you? Was it over the phone or by text?
Over the phone.
Okay. And what's your phone number?
505. This is being broadcast. I really don't want everybody calling me.
Would you shut the feed off, please, for just a moment? It's on.
It's a-
All right. Ms. Thorne.
Mr. Willantis, do you have any other phone numbers that Collin would have talked to you on?
No.
And you're certain that the phone call happened in May of 2024, aren't you? Because you said it happened shortly before the presidential debate where Joseph Biden had to later withdraw from the presidential race, correct?
It was before that. How much before that? Was it a month? Was it a month and a half? Could it have been 2 months? Sure.
You came to court here in Florida back on January 14th of 2025, correct?
Yes.
And you rose your right hand, swore to tell the truth.
Yes.
Do you remember being asked this question and giving this answer? Question. Now, did your grandson, Collin Griffith, then at some later time make some very disturbing statements to you about what he wanted to do to your daughter, his mom? Answer. A few weeks before the disappointing presidential debate in June, which we can all snicker about, Collin was telling me, and then it goes on to repeat what you said earlier, but
Yes.
you remember saying it was a few weeks before the debate.
Yes.
Did you ever call the police about this statement that you claim Collin made to you?
I called the police here, yes.
Oh, I meant at the time that he made it to you, so in May of 2024, or a few weeks before the debate.
No.
Let's talk about your call to the police in September of 2024. You found out from your son, John, that Kathy died, correct?
Yes.
He called you.
Yes.
At some point after John called you and told you that, you watched a press conference that was put on by Sheriff Grady Judd, correct?
Yes.
And you watched it in its entirety, right?
Yes.
And it was about 20 minutes long, if you remember.
About, yes.
And Sheriff Judd described in detail how Kathy died, right?
Yes.
And it was only after you watched that press conference that you took the initiative to call the police here.
Yes.
They didn't contact you as a close member of Kathy's family to get any information from you, did they?
Initially, no.
Right, you contacted them.
Correct.
So you inserted yourself into the situation.
Yes.
Oh, I know what I was going to ask, sorry. Mr. Walantis, how often would you say that you talk to your grandson Collin on the phone?
I don't know. Somewhere between once a week, every 2 weeks.
For what
3
period
weeks.
of time?
It's up to him.
No, up until when? Like over the months since he had been living in Florida with his mom? Every week, every 2 weeks from...
Things dramatically decreased after we spoke at that time.
Okay. So you say that it decreased after you spoke with him in probably May of 2024 and he made this supposed statement to you.
Yes.
Did you text with him still or no?
There may have been some. I don't recall every text, every phone call exactly.
So, Mr. Walantis, can you explain why in Collin's phone records there are a total of 3 phone calls between you two from mid-2023 till September of 2024?
Yes, I can explain why.
Okay. Why?
Well, there's Collin's phone. Collin had an initial phone that his mom got for him. Then he got another phone number. And then often when Kathy would talk, she would then hand her phone to Collin, and we talked from there. So you have 3 different phones.
Oh, do you know what phone you talked to him on every week up until September of 2024?
On my phone. I know
Right,
that
the
much.
phone- the
Which
phone
one?
He was using.
He was on one of the 3.
But only 3 calls on the phone that we are all aware of.
No, there's 3 phones, ma'am, not just one.
The records we have. Sorry.
How do you know what the records?
Sustained.
And you said that there may have been some text messages. So the text messages that are shown by the records indicate that there have been no text messages between you and Collin since Father's Day of 2023 when he texted you Happy Father's Day. Does that make sense?
Most everything was phone calls. There were some texts since then between one of the 2 of Collin's phones.
Do you know where Collin kept this mysterious other phone?
I don't know about a mysterious phone, ma'am. I said there were 2 different phones he had. He had one phone number, and then he got another phone number. And that was something that he and Kathy arranged.
And this is something that Kathy told you.
No. He had one phone number, and I put it in for Collin Griffith. Then he told me that he had another phone number. His mom got him a different phone. So I put that phone number in, and then Kathy's phone, so that's the 3 phones.
I don't have any other questions.
Yeah, just read it. Mr. Walantis, the defense said that you inserted yourself into this situation. Do you recall that?
Yes.
You are the deceased victim's father, correct?
Yes, I am.
Did you insert yourself into anything voluntarily?
When Collin and I spoke about that disturbing phone call, I told him that if anything happened, I would be talking with people officially instead of being quiet.
And does it make sense that the murdered victim's father calls law
Sustained.
Excuse me. Does it make sense that
Objection It's calling for speculation.
Let me hear the question. Don't answer the question until I say so.
Yes, sir.
Did it make sense that the deceased victim's father would contact law enforcement with important information as you did?
Sustained. It's for the jury to decide, Mr. Levine.
Now, when you called law enforcement on September 23rd of 2024, you told law enforcement the disturbing violent statement that the defendant made, correct?
I did.
I have nothing further.
Thank you. Is the witness released?
He is, Your Honor.
Ms. Thornhill?
I have no problem with it being released.
Thank you, sir.
Thank you, Judge.
Mr. Levine, is there a witness that we can call up before a reasonable lunch hour?
Your Honor, there's going to be a witness from out of county that's available at 1 o'clock. The only witness for today is Detective Peters, which will be lengthy testimony.
All right. That witness is not due till 1, or might that witness be here at 12:30? Do you know?
The the out-of-county witness from Charlotte County Sheriff's Office won't be here until 1.
All right, ladies and gentlemen, you're going to have a more leisurely lunch today of about an hour and a half. It sounds like we have 2 more witnesses for the day and cannot start that until 1 o'clock. So please enjoy your lunch and leave your notepads in the chair. I did want, it occurred to me, by the way, yesterday that I think I forgot to tell you during the preliminary instructions, in case you're worried about it. No one's ever going to read your notes, including me. You'll be allowed to take them with you to the deliberations room so that you have your notes there when you're discussing the case. And when your deliberations are over, they'll be delivered to me and promptly destroyed in the shredder in my office, and I will not be reading them. So just so that you can rest assured of that. So please enjoy your lunch and report back at 1 o'clock.
All rise, please.